Aiboan, Vanakkam, Assalamu alaikum, and a very, very good evening to you all joining us from wherever it is you're joining us this evening. Welcome to yet another episode of the AmCham Sri Lanka Legal Review series. And today we're talking about corporate governance and director duties. As usual, what we try to do through this series of webinars is provide you with some insights, both empirical and academic, from experts in the know about the legal jargon and the legalese, as it were, and what your duties and what your responsibilities are, especially in this evolving business environment. So without further ado, let me introduce our panel and then hand over to them to take you through this interesting and very diverse topic, I might add. On our panel today, the very eminent Dr. K. Kanagiswaran, President's Counsel, who, having taken silk in January 1988, is a barrister at law of Lincoln's Inn, a graduate in law from the University of London, and an advocate of the Supreme Court in Sri Lanka. He was conferred a degree of Doctor of Laws and LLD by the University of Colombo at its convocation on the 24th of November 2017, and has completed over 50 years of active practice at the Sri Lankan Bar. He's the chairman of the board of directors of the CCC ICLP ADR Center, a member of the Council of Management of the Institute of the Development of Commercial Law and Practice, also known as the ICLP, and a director of the ICLP Arbitration Center. Dr. Kanagiswaran has written extensively and lectured locally and abroad on several subjects touching his area of practice, and is the co-editor of Arbitration Law in Sri Lanka and the co-author of Company Law. Mr. Nilshantaraj Sirimana, Legal Counsel, has over 21 years of experience in litigation and counseling, specializing in commercial law, constitutional law, and administrative law in the courts of law at Colombo. And he possesses a master's degree in law from the King's College, London, the United Kingdom. Established with his own chambers and practicing law in the Supreme Court, appellate and original civil and commercial courts of Colombo in administrative law, constitutional law, civil appellate litigation, and commercial litigation. He was a visiting lecturer in company law at the Royal Institute of Colombo for the LLB degree program from 2003 up to 2013. Mr. Amir Maroof, Legal Counsel at the Chambers of Quera de Souza PC. Mr. Maroof is an attorney at law holding an LLB from Staffordshire University, UK, and an LLM in international business and commercial law from the University of West London. He's also an associate member of the Chartered Institute of Arbitrators. He currently functions as a junior counsel at the Chambers of Mr. Quera de Souza, President's Counsel, and is a legal practitioner specializing in commercial litigation and arbitration. Your moderator this evening, Ms. Shalini Kulatunga, attorney at law, is a junior legal counsel at the Colombo Law Alliance. She has previously functioned as a paralegal and was attached to the Department of Justice and Attorney General of Queensland, Australia, where she was part of the team that assessed and made approximately 360 grants of financial assistance and compensation to victims of crime under the Victims of Crime Assistance Act 2009, closing, in fact, the highest number of cases and as the youngest government assessor in the year 2019 and 20. Over to you, Shalini, to take us through this interesting conversation that we're very much looking forward to.
Thank you, Rai. So corporate governance, our topic for today, it's a system of policies, processes, and rules that direct and control a business's behavior. And at the very center of it lies the board of directors. The corporate governance framework also depends on the legal, regulatory, institutional, and ethical environment that surrounds a business. Good corporate governance results in a well-performing and sustainable business and fosters a culture of integrity. It also signals to the market that a business is well managed, and as such, it can provide them with a competitive advantage. In quoting Dr. Richard LeBlanc, how a company is governed influences rights and relationships among organizational stakeholders, and ultimately how an organization is managed and whether it succeeds or fails. Companies do not fail, boards do. With that, I put forth my first question to Mr. Nilshantaraj Sirimana. Mr. Serimana, who is a director? What is the role of a director vis-a-vis good corporate governance? And what are the historical underpinnings of the now well-established concept of directors' duties? Over to you.
Thank you, Shalini. Good evening, ladies and gentlemen. As to who a director is an extensive definition which is given by law. But let's just go historically as to who a director is and what the task of a director is. While a company is a artificial construct of law, and therefore it can own its own property and can be vested with its own assets, can manage, can transact in its own name, a company is unable to carry out its tasks and functions alone because it's an artificial construct. So that's where this category of persons called directors come in. They are necessary to carry out the tasks and functions of the company. Now, traditionally, a director has occupied what is called a fiduciary position. The fiduciary position or a fiduciary is akin to a trustee. So then the question arises who a fiduciary is. So the term fiduciary means a person who is entrusted with property and assets to manage them for and on behalf of a principal or a beneficiary. And therefore, a fiduciary must act for the benefit of the beneficiary or the principal and not for himself or herself. Sometimes directors are also considered agents of the company with regard to transactions that they enter into on behalf of the company with third parties. Let's go now to the definition of the term director in section 529 of the Companies Act. You will have to bear with me, ladies and gentlemen. As lawyers, sometimes we tend to be a little technical because our audience is generally or mostly lawyers. So bear with me if I'm being a little technical, but it's necessary to define who a director is. A director is defined very broadly in the Companies Act. And the name or title assigned to a director does not, to a person, does not necessarily mean that person is not a director. If a person occupies the position of director, it is immaterial what title that person is being given. That person will be considered a director. Now, in certain companies, there are people or shareholders who are behind the scenes of a company, but are not on the board of directors of company. Such directors are called shadow directors. What they do is they control the board of directors. The board of directors then are accustomed to managing the affairs of the company or running the affairs of the company in accordance with the instructions of a shadow director. Now, a shadow director is also covered by the definition in the Companies Act. So you can see it's a very exhaustive definition that is given to a director. In addition, there are, for technical purposes, a company is required to submit a form to the company registrar's office. Now that form is generally a form 20, which shows a change in the directorship of the company. So if a director is appointed or if a director resigns or vacates his position, a form 20 will represent who the current directors of the company is. So that's another good way of basically ascertaining who the directors of the company are. Now, directors are loosely categorized as executive directors, non-executive directors, then shadow directors, nominee directors, and some directors may even have contracts of employment with the company. The board of directors as a whole are responsible for running and managing the affairs of the company. And they are also responsible for supervising the business and affairs of the company. So in general, that is a brief description of who a director is. The Companies Act very clearly articulates who a director is. Now let me get to the second subtopic, which is with regard to the historical underpinnings of directors' duties. As I said, this whole concept of a director evolved from the concept of a trustee. Accordingly, the management of the business venture and the property owned by it were entrusted to directors. Now, from this trustee-like position that directors enjoy arose certain responsibilities, which in turn led to duties of a fiduciary nature being imposed on them. Now, chief amongst these fiduciary duties of a director is to act in good faith in the interests of the company. The duty imposed by Section 187 recognizes what is called the duty of loyalty, which is very clearly captured in Section 187 of the Companies Act. Now, apart from this duty of loyalty, there is also a duty for a director to act for proper purposes and in accordance with the constitution of the company. Now, by constitution, I mean the Articles of Association of the company, which is the primary go-to document when you seek to resolve any issue or dispute with regard to the company, apart from the Companies Act. So it is a duty that is cast on a director not to act for what is called improper purposes. Apart from that, the common law of England, let's just say English law, introduced a director's duty of skill, care, and diligence. In the early stages, that is in the 19th century and the beginning of the 20th century, this duty was interpreted in a very lax manner, and also it imposed a very low standard on duties. Now, if I give you an example, there was this case in England where the Marquis of Bute was appointed as a director, as the chairman of the Cardiff Bank at the age of 6 months. He was clearly not competent to be chairman of the company. In 39 years, he had attended only one board meeting. When the company collapsed, this huge bank collapsed, and it collapsed mainly because of the negligence of those who were managing it, the courts did not impose a strict duty on him, on the Marquis of Bute, but merely said that he is only required to give the necessary care at meetings he actually attends, which meant that there was not even a duty on him to attend meetings of the board of directors. So that's how low the standard was. But with the progression of time and the courts getting involved, this duty developed into what is now found in the Companies Act in Section 189. Now, this duty is, when one looks at this section, it's important to understand how this section works. because it's a very clever section. It encompasses what is called a minimum standard, which is an objective standard, and as well as a subjective standard. Now, the objective standard is in limb B of limb A of that section. That imposes the basic standard required of a director. Limb B is used so that it takes it higher from that level and imposes, although it's a subjective standard, it imposes a higher standard depending on the skill of the skill of the director, as well as the qualifications of the director. For example, if a director only possesses an A-level qualification and another director possesses a master's degree, they will be assessed in the same manner with regard to limb A. But when it comes to limb B, a greater duty of skill and care will be imposed on the director who has a master's degree as opposed to the director who has only his A-levels. Now, all these duties existed previously, but they were not contained in the Companies Act of 1982. That was the preceding act to the 2007 Act. For the first time, the 2007 Companies Act incorporated all these duties. In addition, directors also have duties relating to solvency, as found in sections 219 and 20. I won't go into that in detail because of the limited time duration. And the Companies Act of 2007, for the first time, very neatly categorized these duties from section 187 to 200, and in 219 and 220. Other than duties that have come through historical means and which are found in the Companies Act, there are also duties cast on directors which are imposed by other acts of parliament or other laws. Very commonly, these laws relate to mainly labor laws, such as the EPF Act, the ETF Act, and certain finance laws and revenue laws. So that's where other duties are cast on directors by other laws apart from the Companies Act. The directors can delegate their tasks, but they are not absolved from their duty to continue to supervise those to whom they have delegated those tasks. They can't merely delegate and go and play golf and forget about running the company. They have to continue to monitor and supervise so that they are hands-on. The general rule is that directors owe duties only to the company. That is the general rule. In exceptional situations, you may find that directors owe duties to other stakeholders in the company, such as creditors at a time of insolvency and even shareholders at a time of a merger, etc. So those are very exceptional situations, but the rule generally is that directors owe duties only to the company. There is a common misconception that directors owe duties to shareholders, but that is not the case in law. Let me now get on to the topic of the role of a director in good corporate governance. Now, when a company, especially a big company or a group of companies or a massive corporation or a high-profile company collapses, there are severe economic affectations and ramifications. Now, these affectations do not merely affect the shareholders. They affect employees, they affect creditors, They affect suppliers, customers, and members of the public as well, depending on the goods and services that they provide. Now, a good example of this is when the Selinco Golden Key company and the Selinco Sriram company collapsed. Members of the public suffered, members of the public who had deposited money in those companies suffered immensely. Now, it was so severe that the government of Sri Lanka also had to get involved in paying back part of the monies to these depositors. This is where corporate governance plays a vital role. If, for example, proper corporate governance measures had been implemented in respect of those two companies, they would still be in operation. It is that failure to adopt proper corporate governance measures that is most likely the cause of the collapse of those companies. Now, corporate governance came to the forefront as a result of several high-profile companies in the UK and in the US in the late 1980s, ranging up to 2000. Some of these companies were well known. They were massive empires, commercial empires like BCCI, Polypec, the Robert Maxwell Group, the Barings Bank, and Enron in the US. Most of these companies collapsed due to the actions or inactions of the directors of the board. If big companies keep collapsing, there is a severe financial and economic fallout. And what happens is public confidence and investor confidence is destroyed. So that affects the economy as a whole. Now, to prevent such collapses and to ensure investor confidence, corporate governance measures were implemented from time to time to ensure that companies were being properly managed. Now, pivotal in this role of corporate governance is the director. So it is important now to understand what corporate governance means and entails. Put simply, at its widest, corporate governance deals with issues of who should own and control the company. In a narrower sense, it means or it deals with a situation of the relationship between the directors, shareholders, and other stakeholders of the company. One of the key corporate governance issues in many corporations was that the owners and the managers of the company were one and the same. So there was hardly a distinction between the two. Since this whole corporate governance issue relates to owners and controllers or directors and shareholders and other stakeholders, that issue is an important issue to deal with. Now, as corporate governance measures developed over time, those developments aimed primarily at reforms catered for several situations. One of those situations was, or one of the reforms suggested time and again, was that the role of chairman on the board of directors and the role of managing director and CEO should not be combined in one. That is because too much power was concentrated in one person, and that person could dominate the board of directors. So that was the thinking behind separating those two positions and ensuring that two different people held those positions. The other introduction to corporate governance reforms was the title of non-executive director. Now, that is one of the key reform measures that were introduced to basically ensure that there was a check and balance on the actions of an executive director. These directors were required to be independent directors, independent of the executive directors, and were also required to represent shareholder and other stakeholder interests in the company. Apart from that, there was also a reform that was introduced to for the purpose of having subcommittees of the board. Now, those subcommittees concentrated on 4 areas. One is audit, the other is risk and strategy, the third is remuneration, and the fourth is people or talent. Now, those subcommittees were required to be wholly or mainly should consist of non-executive directors and not executive directors. That is again so that those 4 areas are identified as key corporate governance areas where executive directors don't have a real say. It is the independent non-executive director that would decide those decide matters in respect of those committees. So therefore, the introduction of the non-executive director is also an important development in reforms in corporate governance. Just to wind up, I would like to say that the Securities and Exchange Commission, the SEC of Sri Lanka, together with the Institute of Chartered Accountants of Sri Lanka, introduced a best practice or a good practice on corporate governance in 2008, and I believe it has a more recent publication has been put out in 2013 to deal with mainly listed public companies. So those are companies that are listed on the Colombo Stock Exchange. So though that code is not binding on other companies, but will be binding on companies listed on the Colombo Stock Exchange. So those are that's basically my presentation for the first segment.
Thank you, Mr. Sirimana. That was very, very interesting, especially noting the evolution of the trust and to actually draw parallels between the role of a trustee and a director. So that's fascinating. And just a quick question.
Yes.
You briefly mentioned shadow directors.
Yes.
Do we see a lot of that here in Sri Lanka? And for instance, are the names of shadow directors generally disclosed on Form 21, is it, like you said?
No, their names are not disclosed because they're behind the scenes. They're basically like the puppet master, and the directors on the board are like the puppets. You know, the shadow director controls them. So generally, their names are not on the Form 20. There have been instances, I don't want to mention names, but there have been instances where, for example, a very powerful majority shareholder has the power to control the board of directors, because that person will also have the power to remove directors and also appoint directors by ordinary resolution. So some directors are fearful, some may be compliant, and some may merely pander to the whims and fancies of a shadow director. So there are instances. They are not common, but there are.
And it's likely that the liabilities that are attached to a director would then actually lie with the director who is the puppet, like you said, and not the shadow director, is it?
Well, because the definition in the Companies Act of a director catches up a shadow director, those directors also will be liable for the duties and liabilities that are in the Companies Act. So they can't avoid it, except that their names are not on the Form 20.
Thank you very much. That was very insightful.
Okay.
So my next question is for Mr. Amir Maharoof. Now, this is specific to the COVID-19 pandemic. So in your opinion, what is the impact of the pandemic on the obligations and duties of directors? Has it been relaxed, or is there a higher standard that they must adhere to given the financial strains on businesses as a result of the pandemic? Mr. Maharoof?
Shani, I believe we may have lost Amir for a short time. It seems to have dropped off. I think maybe some sort of technical issue. Maybe we can come back to him.
Yeah, we'll come back to it. I'll move on to my next question then for Dr. Kanageshwaran. So again, specific to the pandemic, what are the risks and liabilities that directors are faced with in light of the pandemic? Would you have any insight as to real life experiences of directors involving individual liability in relation to, for say, health and safety, fraud, and so on? So I think your mic's muted.
No, I just saw Mr. Maruf is back. Do you want him on or shall I take him?
I think we can come back to Mr. Maharoof if you're happy to take on the question now.
You know, whatever, I can carry on. Okay.
All right.
COVID and liability of directors, short answer and long answer. COVID, like heart attack or blood pressure or diabetes, has no direct impact on the liabilities of directors. For the simple reason, when you speak of liability, I'm speaking about legal liability, right? So while you may be somewhat sort of made your position difficult in performing your rights and duties, obligations as a director, it has no relationship to your liability. So from a lawyer's point of view, or from your personal point of view, director, we are looking at the legal liability. So legal liability can arise, but only in two ways. Must remember that always. One is a contract. That is a contract between a director and somebody else might cast upon you certain obligations, corresponding duties and rights, things like that. That is contractual. We are not on that. We are on what are the legal duties. The other is by operation of law. The law says these are your duties. COVID notwithstanding, heart attack notwithstanding, whatever notwithstanding, disease doesn't come into it. Though there is a COVID-19 bill in Parliament, which deals with questions of time bars and not keeping into time. If you don't send your income tax return on time, whether COVID or no, time starts running. But there some law has been put in place which might address those delays. But fundamentally, your liability remains what is liable in law. So in law, by operation of law, independent of your consent or otherwise, the law says, as Nilshanta explained to you, certain basic duties arising from the law that say these are your basic duties. Good faith, acting in the best interest of the company, skill and care, and all those things. So, COVID or no, in the excess of your duties and performance of a director, you are obliged to follow that. You see? So, we have then this, it's called civil rights. Now, there is a distinction between civil rights and criminal rights. Criminal liability, there are several sections. Actually, there are some 200 sections in the Companies Act which criminalizes directors, if for their non-performance of certain things, simple, silly things like not sending the details on time, doing that thing, I have no time. So there is a difference between criminal liability and civil liability. So when you speak of civil and criminal liability, I will concentrate criminal liability because in the sense that the act says if you do not do this and the other, you will be found guilty of an offense and you can be fined and sent to prison and things like that. A whole lot of sections on that. So we have no time for that. Civil liability arises by reason of your breach of the duties cast upon you under the law. Right? Now this one fundamental thing is the concept of limited liability That is, a company is different from the owners and the directors, the human agency that makes it up. That's called the limited liability. So the firstly, directors are not liable for the debts of the company. So the creditors can look to only to the company and its assets for to have their action filed. Again, they can't go against the directors. Okay. Then civil liability. So the personal civil liability arises as a result of a breach of duty owed under the Companies Act. Okay. Now, Nilshanta spoke about the obligation to exercise your powers for the proper purpose. So if there have been an abuse of power somewhere down the line, there are stages where what we call a clawback provision, whereby you can ask the company can ask that the company be recompensed by the director acting in default of particular duty. That company be recompensed, that you can draw back. You see, certain actions, certain provisions are there which brings about that. You see, then the question arises: who can make claims against the directors? Your liability is there. Does the company claim it? Who else can claim against the directors? The claims to the directors are in and about the businesses. They are the company. As I said, only if there's a breach of duty can there be any that he'll be asked to answer. And who is the proper person who can make a claim against the director? One fundamental principle is, Nilshanta said, director must remember the duty that you have vis-a-vis the company is owed to the company, not to the shareholder, not to third parties. So it is only the company that can sue you for breach of your duty and the consequences therefore. That is the first principle. Of course, there's a problem because company must act through the directors, human agency. There are two human agencies in a company. The shareholder, they meet general meeting, they may elect a director. The business of the company is in the sole control of the board of directors. Section 184 that says that, that's the common law as well. So they are the ones who will have to act or sue on behalf of the company, because company is an abstract person. So the problem is, will they sue themselves? When wrongdoers are in control, when wrongdoers do wrong to the company, breach of the duty of interests of the interests of the company, excellent skill and care, can you expect them? So the law comes in and brings about what is now also in our law, which is part of a law. It's called the derivative action, right? That is, the law, I don't want to go into details of that. The law has empowered a shareholder, even with one share, to be able to sue in the right of and on behalf of the company, in the name of the company and on behalf of the company, to say that these directors have done wrong by the company, and the court can order recompense be paid to the company. And there is several procedural requirements under the derivative action. You must get the leave of court, otherwise it will become an abuse. People can just come and say, I'm writing, that happens very often in our courts, can be abused. So consequently, the law has come in and said, well, you got to seek the leave of court. The court will then look at why can't the directors do it. Directors come and say, yes, we have fired the bad boy, we will do it ourselves. Then, of course, the shareholders. So the liability then arises principally from the company to them. But there are certain other obligations that the directors do in the discharge of their duties. One is what is called distribution. Company funds are to be used for the purpose of a company only, right? You can't give it to your friends or your girlfriends or anybody else, you see. So that aspect broadly described is called distribution, the utilization of the company's fund for the purpose of the company. Now, what happens if you give it to somebody for some purpose which is not sanctioned by the law, right? In that event, there is a section which says distribution. Firstly, before you can distribute, give away the company's money, it says there must be the company must be solvent. That if you are legitimately exercising a power, the company must be solvent to be able to make distribution. Classic example, dividends. You can't pay dividend when the company is insolvent. So if you do that, then the directors who participated in the distribution, notwithstanding in the insolvency of the company, will become liable, personally liable, to pay back to the company. Likewise, you have corporate governance comes with remuneration. Now, remuneration, if directors can become personally liable to pay back to the company, remuneration not paid in terms of the provisions of the section. There is a section 216, 16b says when and how remuneration can be paid. So if that is breached, then directors become personally liable to pay back remuneration. So the company can sue them, right? And there's all benefit that arises is to the company, not into your personal pocket, right? So here is a liability. Then loans given to directors has been done only under certain conditions, and if that is breached, then that is recoverable by the company. All the recoveries are by the company. The fact that directors themselves may not do so is another aspect of the practical difficulties concerning that. Because one other thing is this: a shareholder doing a derivative action can ask the court reimburse the costs to him. You see, we haven't had full actions in Sri Lanka that gets bogged down through argument and waste of time. But fundamentally, it's so adjusted that I am given the right to shareholder to go against the wrongdoers in control. Maybe I pocket it out, but you can recover the costs from the company, and the court will order the costs, and what you get back goes into the company. Okay, that is a system by which this is arranged. So the liability remains there, different, but the liability, personal liability arises where you breach one of the obligations under the Companies Act, that the director will not act against the law and will not act against the articles of the association. So the law says you can get remuneration only under certain circumstances. It says you can distribute the capital's money, that is dividends, only under certain circumstances. The directors decide. So the decision will not be for a proper purpose. It will be in violation of the article, and therefore they can't get away with it. You will have to cough out. There's a clawback. You can ask, the company can ask that it will be paid back. These are the liabilities directors must be. Now, for instance, insurance. I think there was one question, how can they cover themselves on this? You see, there is provision in the company side for you to get company to give insurance for you, and you can also give indemnity. So that way the companies can see certain that's also under limited circumstances that you can insure. A company can, there is a company is paying money for your insurance, right? Indemnity and things like that. One thing, Nilshant that touched on is the question of insolvency. There is a particular provision in the Act 219. It says where a company is insolvent, or it's not, as we say, is unable to pay its debts as it falls due. That's one of the grounds on which a company may be wound up. It is unable to pay its debts as it falls due. You may be a rich man, landed property, you don't have a cent to buy your bread. You see, that is a liquidity problem. It's a commercial liquidity. Like a company may be full of land and beautiful apartments all over the place, no money. As they say, clean suit, empty pocket. So consequently, there is an obligation on the part of the directors. If they realize that the company is in an insolvent state, that is unable to pay its debts as it falls due, then they'll have certain obligation to be carried out under the Act. You see, that is it says that duty on insolvency. There, if they carry on the business and the company becomes unable to pay debts, directors are liable for the loss occasioned to creditors, right? Because you are carrying on business when you had not the money, and who is prejudiced thereby? The creditors. So the creditors can look to the directors for any shortfall that they have, you see. So the directors become liable for the loss occasioned to the for the creditors. This is another liability. So nothing to do with COVID. Disease has no impact on that. That is the main thing I wish to convey. That disease has nothing to do with it. But that you could not exercise because of COVID or something, your proper due skill and care and skill and things like that is a different matter altogether. So then there is another thing called fraudulent trading. That is, if it is discovered in the course of winding up, I'm quickly taking you through, not to frighten you, but these are hardly ever noticed, which is still there, is not made use of by our courts or anybody else, but these are still there, staring in the face. Would have been applied to, I think mention was made about selling co-crash and various crashes, finance company crashes, liability directors are there. Nobody had resorted to this. The first thing they think of either fundamental rights or some criminal law, right? Because it doesn't get you the money. These are the ways in which you can get your money back from those guys. Okay, that is important. I hope that message goes through. Somebody will. It means more work for Neil Shanta and young Maru. Now, so under this duty, you see, fraudulent trading, if during the course, if during the course of a winding up, it is discovered that the business was carried on with intent to defraud creditors of a company, that is one, or any other person, or for fraudulent purposes, liability arises to contribute to the assets of the company or personally responsible for such debts, liabilities to the company. So the director become personally responsible for such debts and liabilities of the company. Just apply this section to some of these financial fiascos. Why it was not done, don't ask me, right? They bark up the wrong tree. Our lawyers do, you see. Then, if during the course of winding up, this is only during the course of the winding up, it discovered, it's proactive. In the course of the winding up, if it is found money or property of a company has been retained, put it in your pocket, misapplied, or become accountable, you had to be accountable, you did not. You are guilty of negligence, default, breach of duty, breach of trust. You can be ordered, when I say you, the directors, can be ordered to pay money or restore the property or contribute to the assets of the company. All these are there. It is saying none of these have been worked in this country in a way which is beneficial to the society and send a lesson out into the commercial world. It's a tragedy because this act has been there from 2007. These provisions are there before, as Nishanta said, it was part of the law. We had to go to the lawyers to look for it because it was in the common law, not in the statute book. We have codified all this in this current act so that those with eyes to see can see, and those who desire to clean up the system can do so. There are many other sections under which a director can be ordered to carry out various things, obligations under the act by orders of court. There are sections under which the director can be ordered to carry out obligations under the orders of court and things like that, you see. Then there is a thing called tortious liability. Those who know something. There is a contractual liability under the operation law. Tortious liabilities, classic cases, examples are negligence. Now, one of the obligations of the directors is put out a prospectus when they want to raise funds in the market. Prospectus is a very sacrosanct document that tells you the reason why you're raising, and people rely on it. You see, it is a fundamental principle. Any misstatement in the prospectus, a document that you put out, I don't know how I am running for time, put out to raise capital, right? If you make a misstatement, actions can be brought against the directors for damages that have been occasioned by that misstatement. Who is anybody? Third parties out in the market, out in the field, on the faith of the prospectus, they put money into the company, raising shares and things like that, then that can be. Now, we haven't heard of cases against accountants for misstatements. There are cases, but this is prospectus, a document put out by the director themselves. That is a tortious liability, you know. But in the case of, but law is not all that draconian. There is a section in the Companies Act which says, in the event of such tortious claims, things like that, that is in the case of negligence, default, breach of duty, breach of trust, court directors can seek relief from liability if they had acted honestly and reasonably in all the circumstances. That is where one thing Nilshanta flagged is, if you are an SSC qualified fellow and not an accountant, you may be judged differently because you can seek the advice of expert on the subject of each year that's specifically provided for in the Act. So one can argue, I did this in the honest with good faith, in bona fide belief, on the advice of so and so, at that time, thinking it was in the best interest of the company. So there is possibility of relief for breach of duty, negligence, breach of trust, and things like that, if we can demonstrate that they acted honestly and reasonably in all the circumstances. So it's not a strict liability as they call it. There is a defense open, it can be done. Criminal offences, as I said, there are some 180 or so specific criminal offences which touch upon, which takes it sends you to jail. For, you might think they are stupid, but still it is there to see that you do abide by the law. One is the civil, one is the criminal, and in between you get the classic tortious claim, which is also part of the civil. These are the liabilities that I thought I'll say that because COVID disease has no impact on it. So I'm sorry, whether COVID or no, all these obligations, you take it to bed and you get up in the morning, you carry with it. So you have to be aware and you have to manage it that way, right? Would that answer your question?
Oh, definitely, Dr. Kalamishwaran.
I don't want to exceed my time. Thank you.
No, it's perfect. Thank you. Mr. Maharoof, so do you share the same opinion that Dr. Kalamishwaran just posited? Are you also of the opinion that the COVID-19 pandemic hasn't really had an impact on the risks and liabilities of directors, and what is your take on that?
Yeah, I'm also of the same opinion because the duties cast upon directors are codified and in the Companies Act. So regardless of the change in circumstances of the country, those duties won't go away. If at all, I would feel that at some point the standard expected from directors may be considered to be higher than usual, because you would have to be more aware of what is happening. For example, due to COVID, new regulations come into play. So, and as a director, you will have to think of matters like compliance, complying with those regulations. Then when it comes to taking care of your human resources, I remember there was another webinar on that AmCham carried out where a certain director spoke about where they did not have pay cuts for their employees, and then making sure that you act in the best interest of the company at the end of the day. Right? So I feel that if at all the degree expected from a director may be needed to be looked into at a higher standard at times like this, but those duties that are enshrined or codified in the Act will always remain the same.
In terms of corporate governance, now we have the duties and obligations of the directors on one hand, and we have corporate governance, which is basically a much broader topic, correct me if I'm mistaken. How is corporate governance affected, or what are the additional rules that should be in place given the pandemic? Is there such a thing? Maybe Dr. Kanageshwaran or Mr. Siriman or Mr. Maharuf could answer that question. Dr. Kanageshwaran, your mic's muted again. Sorry.
Right. Well, the corporate governance, it, the subjects it deals with, global trends, addresses both quality and composition. So both quality and composition is at the heart of corporate governance, as Nilshanda told you, because they are expected to be vigilant as they consider individual events that is happening in the best interest of the corporation. So COVID is a challenge there in the decision-making process. You see, you will have to decide whether to close down, half close down, full close down, quarter close down, what provisions will have to make for your workers to come to. All those things will have to go into the decision-making process. And that, of course, you are looking at, of course, your profit also. Business is there for profit, not for charity. So all those things will you will have to make some difficult decisions. The problem arises if by reason of that, that's how I look at it. Decision making depends on what the company business is. If there's no business, there GST plus goes away. What you had to shut down your textile. Then you're looking at the guys, laying or handshakes or whatever. See that you don't walk away with like in the US, walk away with a massive, handsome goodbye package and things like that. All those will come into being. The point is if at any time, this is what's been troubling me, because I don't know, our judiciary doesn't really appreciate this. It's this, because at the time, this is something directors must take up and instruct their lawyers to fight for. Namely, it is not easy to make decisions at times like this, because you will, for the moment, decide this is the best course, because tomorrow it might be worse. Right? So if one cannot say the decision you took at this time was not in the best interest of the company. On hindsight, because when the matters go to court, then the judges are looking at, it'll take a couple of years to get there. This guy could have done it, no, not there. So the question arises, when you say whether you acted in the best interest of the company or no, at what point of time are you looking at it? Right? One of the great principles of corporate law, I want to leave that message out there, is that the final word on the internal management of a corporation is for the board of directors. The decision they make now, in the circumstances in which they are called upon to make, the consideration that put into place, the advice they seek are relevant and immediate at the particular point of time. And court says, English law says, and is very loud and clear, court does not interfere in the internal management of corporations acting within their powers. That is one. The other is, courts will not, a whole lot of English judgment, we don't get them in Sri Lanka, whole lot of English judgment will tell you that you cannot, in hindsight, decide what was done at that time was right or wrong. Because it's called the business judgment rule. I make my judgment today in the course of my business. That is business. You must look at it the common sense. At that point of time, were they right to make this decision? Because tomorrow the rupee might go down to 400 rupees. You are looking at today at 220. I mean, in the curb market, it's, I don't know, they say 230 or whatever, I don't know what the central bank says. So you cannot, if you're looking forward, no, that also you can't do, no? Anyway, if you're looking forward, you see, you'll have to take a decision about whether you'll go up or down. So you cannot later say, find liability. That is an important, that is, you will not, in hindsight, make a judgment of event that happened before, long before, but it will be judged whether they were right at that point in time. So that COVID or no, you have to be careful in making decisions to be able to justify at the time you made that decision you were the best that would have been done. So that matter of recording is important. I don't know, keeping our minutes is for that purpose. It should reflect the fact that you have addressed your mind to various issues. You have sought legal advice, depending on what the problem is. Or you're looking at economic factors, whole lot of things, political factors, environment factors, and say, this is best we can do. Then you cannot be found fault with for not having observed the duty of due skill and care and the best interests of the company. Right?
Wonderful guiding principle. Thank you, Dr. Kanageshwaran. I think that brings us to the end of this particular webinar. Thank you very much, sir, Dr. Kanageshwaran, Mr. Mahroof, Mr. Siriman. Rai, over to you. I don't think we have any questions from the audience. We might have questions coming in later. So over to you, Rai. Thank you very much.
Thank you very much. So we've actually decided to limit the questions because we thought we'd like to stop on time. It's been a long day, I'm sure, for everybody. And also the content that was shared was, it gives enough food for thought for us all to kind of go out and go back to our homes and give it a little thought. So audience, as usual, please feel free to send your questions in to us via email. We'll be more than happy to share it with our panelists and share them back with you if there is anything at all that we can be of further assistance with. On behalf of AmCham Sri Lanka, my sincere thanks to all of our eminent panelists for taking the time today and for sharing your insights and your invaluable knowledge. Shalini, thank you very much for moderating this session. And as usual, I'm sure you will do a wonderful job assisting us with the publication to follow as well. And of course, to all of our viewers, our participants on Zoom, as well as our viewers on Facebook and on YouTube right now. Thank you very much for watching and thank you for your participation as always. A reminder to like, subscribe and share the videos because of course this is what helps us to continue bringing these resources to you free of charge, which is part of what AmCham wants to do, which is to build you a knowledge resource hub that will help you with your business continuity despite whatever the challenging circumstances may be. As we leave this evening, once more, a reminder from my eminent panelists, from the AmCham Secretariat and myself to stay safe, stay healthy, and good night and God bless. Take care. Bye-bye.